Hello friends, welcome to AD Dictation. So here we come with a new legal passage. You will find journal dictations in the playlist. These dictations are important for upcoming exams of lower and high courts. If you find this channel is helpful, then please subscribe and share with your friends. To receive instant updates of upcoming videos, please hit the bell icon. If the video helps you in your preparation, then please give it a thumbs up. It will motivate us to upload more dictations. All playlist links are in the description below. Please check it out. Let's ready? 5 seconds.
Start. Now the question that begs consideration in the light of the submissions advanced across the bar is whether the principles of natural justice were observed in compliance or not. As stated herein above, Rule 81 of Rule 1976 does prescribe observance of the principles of natural justice. From a close scrutiny of the inquiry report dated 29/10/1993, it transpires that the inquiry officer has found the petitioner guilty on the basis of the reply to the charge sheet submitted by the petitioner and other documents, but not a single witness was examined by the inquiry officer in the presence of the petitioner, and also no date, time and place was fixed by the inquiry officer. It is not discernible from the inquiry report that the petitioner was never granted any opportunity of personal hearing or cross-examine the witnesses, and in the circumstances there appears to be non-compliance of Regulation 81 (small a) of the 1976 rules, which enjoins due observance of the principles of natural justice. In this connection, Article 14 of the Constitution of India may also be referred, which clearly postulates that authority competent to pass orders is required to record reasons, which is one of the principles of natural justice governing exercise of power by the administrative authority. It is well enunciated in various decisions of the High Court and the Apex Court that the disciplinary authority has to apply his mind to the record apart from the finding recorded by the inquiry officer before coming to the conclusion whether the charge of misconduct has been proved against the delinquent. Para. Merely asking the petitioner to submit an explanation, in my opinion, is not sufficient where it is proposed to impose a major punishment. There are two kinds of hearings, a personal hearing and a second non-personal hearing. When it is proposed to impose a minor punishment such as withholding of increments or a fine or warning, a non-personal hearing would suffice. In a non-personal hearing, all that has been done is that the delinquent employee is issued a show-cause notice to which he gives a written reply, and on that reply the punishment is straightway imposed, giving reasons. In such a case, it is not necessary to hold a full-fledged oral inquiry, giving the concerned employee an opportunity of producing his witnesses and cross-examining the witnesses against him. However, when it is proposed to impose a major punishment like dismissal, ordinarily a full-fledged inquiry must be held. This is because a major punishment not only has very serious consequences upon the employee but would adversely affect the family. Hence, the law imposes a stricter and elaborate procedure requiring a full-fledged oral inquiry in cases of major punishment. In such cases, it is ordinarily necessary for the employer to issue a notice to the employee indicating the date, time and place of the inquiry after appointing an inquiry officer. On the date and time fixed, the witnesses against the concerned employee is required to be examined ordinarily in his presence, and he must be given an opportunity to cross-examine them. Para. Coming to the aspect of observance of principles of natural justice in the instant case, it is explicit from a perusal of the inquiry report that no date, time and place was fixed by the inquiry officer. As stated herein above, it would crystallize from a perusal of the inquiry report that the disciplinary authority did not reckon that the inquiry officer did not fix any date, time and place, and no witness was examined by the inquiry officer. The Apex Court has repeatedly emphasized for observance of the principles of natural justice. In Minglas T. Estate versus their workmen, AIR 1963 SC 1719, the Supreme Court propounded in clear words that it is an elementary principle that a person who is required to answer the charge must know not only the accusation but also the testimony by which the accusation is supported. He must be given a fair chance to hear the evidence in support of the charge and to put such relevant questions by way of cross-examination as he desires. Stop.